Gandang araw po muli sa ating lahat. Ito po ang inyong lingkod, Kleng Austria, your Juris Doctor, para sa aking segment na Tidbits of Labor Laws. By the way, ang Juris Doctor po ay hindi doktor sa medisina, kundi Doctor of Law or Batas, o ang tinatawag din po na Doctor of Jurisprudence. Alright, so ang topic po natin ngayon ay hanggang kailan lang pwede mag-file ng labor complaint ang isang empleyado laban po sa kanyang employer o kumpanya. Mahalaga po na alam natin kung hanggang kailan tayo pwedeng mag-file ng labor complaint sa tanggapan ng NLRC para hindi po mapaso ang ating mga karapatan na maghain ng kaso laban sa ating employer o company. Bilang buod o summary, ito po ang period of filing complaint. Una, money claims ay 3 years, ang ULP or unfair labor practice ay 1 year, at ang illegal dismissal naman po ay 4 years. Papaliwanag po natin ito ng isa-isa para po mas maintindihan po natin. Kaya markahan niyo po ang inyong kalendaryo kung kailan po nangyari ang mga bagay na ito na ipinagkait po sa atin or hindi po naibigay yung mga nararapat po na pananalapi na matanggap natin kaakibat po ng ating pagtatrabaho at ganun din kung kailan po nangyari yung unfair labor practice o kung kailan po tayo na-dismiss ng illegal ng ating employer. Okay, unahin po natin ang money claims. Monetary claims have a prescriptive period of 3 years. Under Article 291, it says, money claims. All money claims arising from employer-employee relations accruing during the effectivity of this code shall be filed within 3 years from the time the cause of action accrued. Otherwise, they shall forever be barred. Ibig sabihin po, ang money claims na ito ay nakapaloob lamang sa relasyon ng isang manggagawa at kanyang employer. Kung ito po ay utang na walang kinalaman sa relasyong ito, hindi po ito maaaring i-file sa tanggapan ng NLRC, kundi sa mga regular na korte. Ayon po sa Article 291, mayroon lamang 3 taon mula nung hindi maibigay o ma-deprive ang empleyado sa mga kaukulang sweldo o benepisyo na marapat niyang matanggap. Kapag lumagpas po ito ng 3 taon at hindi nag-file ng kaso laban sa kanyang employer, hindi na po ito maaaring magdemanda pa para makuha ang mga benepisyong ito, sapagkat napaso na po yung karapatan niyang maghabol sa mga benepisyo na dapat niyang matanggap. At kapag na-file niya yung kanyang complaint within the 3-year prescriptive period, please take note that the money claims that can be recovered are limited to these claims which accrued within the 3-year period immediately preceding the filing of the complaint or amended complaint. At kapag na-file po niya ang kaso within the 3-year prescriptive period, ang maaari niya pong ma-recover ay limited lamang din po sa benepisyo sa loob ng 3 taon niyang pagtatrabaho, kahit po siya ay nakapagtrabaho doon ng more than 3 years. At ang bilang po nito ay pabalik. Okay? May example po ako dito. If employed in August 2015 until September 2020 or for a period of more or less 5 years, an employee may file money claims until September 2023, which is 3 years from August 2020 as the prescriptive period for filing the complaint. At dahil limited din po sa 3 years ang maaari niyang makuha, so ang period na mako-cover para sa 3-year na benefits na dapat niyang makuha ay mula lamang po sa 2020 pabalik po ng 2017. So hindi na po niya makukuha kung ano man yung mga hindi niya natanggap mula 2016 hanggang 2015 dahil outside na po ito ng 3-year period. And please take note that prescriptive period applies to all money claims including retirement benefits. The prescriptive period referred to in Article 291 of the Labor Code applies to all kinds of money claims arising from employer-employee relations, including claims for retirement benefits. In the Guzman v. Court of Appeals, the Supreme Court held that the language of Article 291 of the Labor Code does not limit its application only to money claims specifically recoverable under said code, but covers all money claims arising from employer-employee relations. Since petitioners' demand for unpaid retirement or separation benefits is a money claim arising from their employment by private respondent, Article 291 of the Labor Code is applicable. Therefore, petitioners' claims should be filed within 3 years from the time their cause of action accrued or forever barred by prescription. Moving on to number 2, it's unfair labor practices or ULP, the prescriptive period of which is 1 year from the time of the violation. Okay, so under Article 248, unfair labor practices violate the constitutional right of workers and employees to self-organization, are inimical to the legitimate interests of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect, disrupt industrial peace, and hinder the promotion of healthy and stable labor management relations. Okay, so I will discuss this in a separate video for more detailed information. Alright, moving on to number 3. For the filing of illegal dismissal complaints, the prescriptive period is 4 years. The prescriptive period for filing an illegal dismissal complaint is 4 years from the time the cause of action accrued or from the time of illegal dismissal. This 4-year prescriptive period, not the 3-year period for filing money claims under Article 291 of the Labor Code, applies to claims for back wages and damages due to illegal dismissal. And settled is the rule that when one is arbitrarily and unjustly deprived of his job or means of livelihood, the action instituted to contest the legality of one's dismissal from employment constitutes in essence an action predicated upon an injury to the rights of the plaintiff as contemplated under Article 11462 of the new Civil Code, which must be filed or brought within 4 years. Alright, a question that comes to mind is, what if the complaint is withdrawn? Will this affect the period of prescription? The answer is no, it will not affect the period of prescription. In a case decided by the Supreme Court, the petitioners contend that the period when they filed a labor complaint was on May 14, 1998, but withdrawn on March 22, 1999, should be excluded from the computation of the 4-year prescriptive period for illegal dismissal cases. However, the court had already ruled that the prescriptive period continues even after the withdrawal of the case as though no action has been filed at all. Ibig sabihin po, hindi po maaapektuhan ng pag-withdraw ng complaint yun pong period of prescription na 4 na taon. At tuloy-tuloy lamang po ang pag-prescribe nito hanggat di po nagfa-file ng kaso. At ang sabi po ng Supreme Court sa case ng Intercontinental Broadcasting Corporation versus Panganiban, the applicability of Article 11554 of the Civil Code in labor cases was upheld, where the court held that although the commencement of a civil action stops the running of the statute of prescription or limitations, its dismissal or voluntary abandonment by plaintiff leaves the parties in exactly the same position as no action has been commenced at all. In like manner, while the filing of complaint for illegal dismissal before the labor arbiter interrupted the running of prescriptive period, its voluntary withdrawal left the petitioners in exactly the same position as no complaint had been filed at all. The withdrawal of their complaint effectively erased the tolling of the reglementary period. Hanggang dito na lang po muna at hanggang sa susunod po na video para sa ating tidbits of labor laws. Nawa kayo po ay may natutunan at marami pong salamat. At huwag po ninyong kalimutang mag-subscribe. Mag-comment po ng inyong mga katanungan at sasagutin ko po ito sa abot ng aking makakaya. Bye!